Ladies and gentlemen, I want to make this forward in three levels in this way. Firstly, I want to explain further about how victims feel in that circumstance. We believe, regardless the tangible bias exists or not, right? We believe that how they suffer, how they feel is more important because it strongly hinders the quality of the rehabilitation in the first place, this speaker. And secondly, I want to explain why uniquely in this case, in a model, can we tackle the existence of the bias, especially exclusively in the jury, between juries in the court, Mr. Speaker. And thirdly, I want to explain about the comparison here, ladies and gentlemen. Why this kind of bias or improper punishment can be overridden by our power, Mr. Speaker. But before maybe now, I have one information called the opposition bench and the open government, opening opposition. So opening opposition has explained this. Principally now, to eradicate that kind of information and so on and so forth, you have to utilize maximum information and so on from Mr. Speaker. But we don't think so, right? Simply because when I talk about the status quo current condition, right? We don't invite a friend of the criminal, friend of the victims, right? And also we never ever invite the people who are familiar with the background information or slum or any kind of economic condition or so on, Mr. Speaker. That's why we believe that in the past principally the argument doesn't make sense in the first phrases. So recognize that I'm moving on my first issues in this way. How victims feel, and it's so important regardless of their tangible bias exists or not to begin with. No, thank you. Mr. Speaker, opening government explained superficially how they feel in the societal level, Mr. Speaker. Very first right? How they feel, especially the victim or suspected criminal, Mr. Speaker. I have two mechanisms. Firstly, we believe that if the victims or criminals are in the court, right? When they see, for example, they are African Americans, Mr. Speaker, when they see white juries in the court, ladies and gentlemen, they have to necessarily suffer from a possibility, right? To discrimination or heavier punishment, they have to suffer from such kind of possibility in the first place, Mr. Speaker. And moreover, we say, so they have to suffer from the fear of improper punishment because in the society there is discrimination and so on and so forth. The government opposition has said, right, this is random choosing and so on and so forth, but it never ever denied the possibility of discrimination or racists are included in the first place, Mr. Speaker. That's why they have to suffer and they have to feel, right, possibility of discrimination and improper punishment. And secondly, more importantly, exclusively in this debate, I'm sorry sir, in the context where the technology do exist, Mr. Speaker, government and society are complicit, ladies and gentlemen. Even though the technology exists, but government never positively utilize that kind of technology, Mr. Speaker. The government did not do the best effort to eradicate such kind of barriers or discrimination in the court, ladies and gentlemen. How they feel is that the government are complicit, governments are not positively tackling that kind of discrimination or bias to begin with, ladies and gentlemen. That's why we believe that the victim or criminal feel that they are to some extent unfair position, that unfair judgment has a possibility to be done, ladies and gentlemen, in the first places. So why is this so serious in the first place before webinar closing?
Why invisible value like a fear should be prioritized over proportionate punishment on the basis of a maximum amount of information the jury should access to?
Okay, I will explain my third issue as a comparison, but later, please. So, webinar, why is so serious problem in the first place, right? I think, ladies and gentlemen, it strongly hinders the quality of the rehabilitation to begin with, ladies and gentlemen. I believe simply because the rehabilitation and anxiety or unfairness mind itself is so strongly counterproductive for the quality of the rehabilitation in the first place. Why is that so? Simply because the regulation is should be predicated on that kind of credibility or trust of the court, Mr. Speaker. That's because simply because the time in the imprisonment or time in the jail, or you have to face what you've done at the same time, you have to face what you are receiving as a punishment, ladies and gentlemen. All day long you are in prison, right? All day long your rights move freely, or any other kind of right are infringed, Mr. Speaker, right? When they compare what they've done and what they are receiving as a punishment, right? They have the time opportunity to regret in the first place. No, thank you, Mr. Speaker. In that circumstance, we believe, because there is a possibility of the heavier punishment, improper punishment, they cannot recover for enough way, Mr. Speaker. Why is that so? Simply because those people have untrust or they lose the credibility towards the court. They cannot trust that kind of actor in the society, and those people will do that. Will not regret in efficient manner, Mr. Speaker. It's so problematic to begin with. So, it strongly hinders one pillar of that punishment function in the society, ladies and gentlemen, rehabilitation is one kind of important factor in this debate. No, thank you. So, secondly, I want to move on. My second issue is why can we tackle that kind of the core problem of the bias in the society, Mr. Speaker? So we don't think that almost all people have the bias in even the United States of America and so on and so forth. And we concede, but we have to acknowledge there are some people who have this discrimination even in the society, ladies and gentlemen, or bias, or racist idea, Mr. Speaker. In that circumstance, why uniquely eradicating such kind of information can tackle that kind of racist idea, or so forth, ladies and gentlemen. Why would it? Let's take an example or analogy of Rawls ignorance veil, Mr. Speaker. If the people don't know any kind of idea or any kind of condition they are or that they are located in, right? They want to pursue that fair condition, Mr. Speaker. And same must apply here, ladies and gentlemen. If the people are racistic idea, ladies and gentlemen, no thank you, sir. They don't know jury's character, jury's background, ethnic condition, ladies and gentlemen. In order to maximize benefit of their own ethnicity or racism or race of their races, they want to try to eradicate unfair bias because it can lead to the harm on their own ethnicity, Mr. Speaker, by using that unfair judgment, ladies and gentlemen. That's why we believe tenure bias can be materialized and can be tackled down on the closing domain because we tackle the bias in the code, and I think a beautiful code, as the opening option explained, those kind of things can be achieved exclusively on the burden, Mr. Speaker. Thirdly, quickly I want to explain about comparison here, Mr. Speaker. The open domain has said that the bias have the possibility of the bias exists and there is a possibility of improper punishment. Opening option has said that they don't know the background and so on and so forth. Also, improper punishment can function well. There is a whole possibility both. I think that this is so difficult to conclude. Which kind of improper punishment is so heavier and so on and so forth. I think that the tiebreaker in this debate is how they feel in the first place. Even though there's possibility of improper punishment, right? Those people who receive the punishment can actually at least rehabilitation, can do the rehabilitation, Mr. Speaker. Even though under the possibility of for improper punishment, we can achieve, at least we can save the victim, we can save the suspected criminal. That's why we stand here on the closing. Thank you.
Mr. Speaker, our stance coming from the closing opposition is very clear. We want to have races and ethnic as one of the criteria that is going to be given to juries and judges. Just like how we give priority conviction, gender, finance background, height, appearance information, relationship with family, friends, and romantic relationships, sexual preferences, we tell you every single information is integral to the decision, to the verdict, because we believe that every information is ultimately going to lead to the truth of that simple crime. We tell you, Mr. Speaker, when every single crime is happening, that's varied, and when we do not have an absolute same crime to begin with, we do not believe that we should try to proactively and preemptively and subjectively choose that this is good and this is bad. Because we believe that every information should be given to these juries, and these juries will contemplate based on that information. Second of all, we tell you, Mr. Speaker, we do not believe that juries are biased in the first place, and even if there is, we say that we're more than happy to remove the perception. What are we talking about? For instance, even in the status quo, we actually have authorities vetoing against racist juries. We're more than happy to have that, right? We're more than happy to have these implicit instructions that was given to the juries to have these to make it as impartial as possible, right? We tell you there's any other alternative that can be taken in order to tackle down the perception, and we do not believe that what they're trying to propose is something that's beneficial to tackling this issue. So the opening opposition side today mentioned about the point of court's role and how there's a public perception. What the closing opposition is going to bring to is how when jury decide verdict and sentence, what kind of practical influence we can see towards the police, towards the prosecutors, and towards the process itself, and how it is something that will lead to benefit more of a better practical influence in our side of the house when we have these races and ethnic. So based on that, I'd like to bring two new extensions. First of all, how ethnic and racist is something that's indispensable when we consider the process of verdict, and the process given for these juries to actually decide a verdict. Second of all, let me tell you why in their part, that without these races and information, why it is something that's going to be much more worse when they're going to rely on more dubious, less accountable material. So moving on to my first issue, 4-level analysis. First of all, we tell you, Mr. Speaker, racist and ethnic, just like how like poor people and gender, like in the case of gender, in the case of hatred, we actually have many of the accidents that is dependent towards the motive of that accident. Right? We tell racist and ethnic can be applied, and many times the motive to actually commit that crimes in the first place. Just like in the case of Ferguson, just like how when white police actually try to attack Michael Brown, we tell you, Mr. Speaker, that motive, that ethnicity and racism may become the motive in that very aspect. That's why we say when we see coming from the opening government side, really like, funny like models when they said about how the concession is relevant. We're more than happy to prove that. We said that in your side house, we're like not going to have any kind of information to actually be given to these juries, and we see that's something that's hugely problematic. Right? Moreover, we tell you, Mr. Speaker, that's also why we actually like try to contemplate on whether that criminal actually had the intention, the malicious intention to commit that crime in the first place. Right? That's why we say to Mr. Speaker, when we consider that there is a direct effect, when we consider that these races and ethnic is something that's a motive that's considered when these people actually like commit these crimes, we say it's hugely problematic. Right? That's also why we actually have a hate crime law that actually try to decide that normal criminals actually killing is something that's different, like race-based killing, which we have which we believe that in their style you simply undermine proportionate punishment. What we see coming from the closing government side is a really interesting argument of rehabilitation. Right? We tell you, Mr. Speaker, when you actually know the motive, when you actually know the ethnic, when you actually know the races, you're able to rehabilitate more in our side of house because these people who are incentivized based on their races and ethnic will be able to become much more being rehabilitated, will be able to like know much more better of the intention that they actually do. Right? Secondly, we tell you, Mr. Speaker, we tell you in many cases these prosecutors are also biased, and we tell you every single jury actually have the right to be able to know whether these prosecutors is biased or not. Just like we actually have the right, just like how the jury actually have the right to know whether there was a pre-bargaining or not. We tell you, Mr. Speaker, in the case of indefinite detention, in the case of forceful confessions, in the case of racial profiling, we tell you these jurors actually have the right to be able to know whether the prosecutor was biased or not. But moreover, we tell you in your side of health, there is going to be more aggravation when there is going to be a moral hazard within the police. Right? What are we talking about? Because these ethnic and race are not going to be appealed to the society, are not going to appeal to the juries, these police are more likely to commit these crimes, more likely to investigate to these black people and say that you are going to be prosecuted. Right? That's why we say that it's going to be much more aggravated when these police are not going to be able to like be much more like unbiased in your side of house, rather much more biased in our side of house. Third of all, we tell you, Mr. Speaker, the social perception that actually exists in the society is something that's accountable to the criminal justice system. Okay, I'll take a few.
So even if you consider the best case scenario, even if you consider the maximum unbiasedness is achieved, however, when Michael Brown was shot by a white policeman and what court decided, the white male judges decided not to prosecute that, then people distrust and people raise that and this like.
First of all, we tell you that in your part that you actually undermine proportionate punishment. But second of all, as the opening opposition has briefly alluded to, we're more than happy to have any diverse juries if that's a problem. Right? We do not believe what you're trying to propose is something that's a solution. To begin with, sit down. We tell you, Mr. Speaker, the fact that actually these sentences affect the society, and the fact that this crime actually have this verdict, this crime actually have this sentence, we tell you these courts actually interpret the law and try to decide based on these juries' decision. Right? We tell you, Mr. Speaker, and that's why we say that when in your side you have to create a precedent, it actually affects the future cases, future legal system. Right? And why is it so problematic? Right? Not only these other juries in the future will be affected by the system, we said that in the society people actually accordingly act in the society when they look at these laws. Right? We said that that's precisely why we see that in your side house when you're actually constructing this social norm of jury, social norm that this is good and this is bad. We say that's something that's hugely arbitrary and that's hugely something that's bad. Right? First of all, we tell you, Mr. Speaker, these suspected criminals are not criminal yet. Right? That's why we say that these suspected criminals actually have the right to be able to consider these ethnic and races as a mitigating factor, because when they want to insist on an innocence in your side of house, these people are completely neglected. Right? We say that's worse in your side of house, and that's why we say in our side of house is something that's better. Moving on to the second issue of what kind of information you're going to expect in your side of house. Because you don't have any races and ethnic and any information, you're simply going to look on other information. What are we talking about? Such as devices of evidence, testimony, witnesses, and circumstances of evidence, which we see is completely much more dubious, completely less accountable, completely less reliable in this aspect. Right? Because we say that in your side of house, these people are more going to concentrate on this dubious information. We say it's something that's going to be worse, because we say that as the partner has mentioned in his BOI, precisely because these people are hugely influential, these people are going to much more rely on this information, which we see something that's hugely problematic. So at the end of the day, we need to be really comparative in this debate, because in your type of house, you only consider this gender, you only consider this dubious information. While on our type of house, we're able to create moral balance, to be able to contemplate better information, contemplate on a diverse, every single information is given to the jurors, to have an impartial verdict. We're very happy to oppose.
Member of the opposition, got the left. And later instructions to
this debate from the two perspectives in summation. First of all, I'm going to talk about principal justification of this kind of proposal, and second of all, I'm going to talk about how the court procedure will be after plant action. So all about will be integrated. So first of all, principal justification. The AGU mentioned that we respect the humanitarian aspect or human aspect. First of all, even in the status quo, there is effort to remove the emotional biases of the individual and as a human being. Like we do not choose the juries as the friends of victims or suspects and so on and so forth, because there is a lot of humanitarian biases, or anonymity is guaranteed for the victim. For the juries, because in order to minimize the fear of the revenge of the fear, because both of them is humanitarian emotion, but we still do not respect this kind of humanitarian aspect in the first place. That's why as long as race bias is particularly important in this kind of racial, controversial country, we think that we do not respect this kind of humanitarian aspect in the first place. And second, we say the court is also the institution of caring the victim or suspect in the first place, because closing opposition mentioned that they prioritize proper punishment and so on and so forth. That's the case of we do not broadcast the court trial itself, because in order to protect such kind of anonymity of victim or other things, or in terms of rape victim, in order to avoid such kind of make the second day the baby interviewer is avoided in the first places. This kind of the court is particularly institution of the caring the victim or suspect in the first places. That's why I say even under our paradigm, in order to care this kind of proper fair punishment, fair trial, we think this is particularly justifiable. No. So what is important extension coming from outside the house is we do not debate on the real world. We debate on the assuming world that the technology already exists. Even opposition side have to protect the world inside such kind of assuming the technology. That's why I say in this particular context, we think the technology, everybody understands the technology do exist in the first places. In this particular case, we think the states that victims or minority they understand. No, we can't states of this kind of racial preconception in the first places. We think because the technology to remove these kind of racial biases, especially racial biases, do exist, but still they do not introduce in the first places. We think in this particular situation, the preconception of the fear of this kind of preconception is particularly serious in the first places, because we say court or the jury, criminal justice system is also important, has the also important aspect in terms of rehabilitation and retribution in the first places. In terms of suspects, if these kind of people feel that because of racial preconception they get a heavier punishment, in this particular situation, the rehabilitation, the efficacy of rehabilitation will severely diminish in the first places, because we say in terms of regulating procedure, we can accomplish the rehabilitation procedure, but we say that not because they do not regret this kind of committing crime itself, but they just regret that they are born in the African American, because that's the reason why they get the heavier punishment is that kind of system of preconception. Just believing in this kind of particular bias, we think this is particularly harmful in terms of rehabilitation, because their rehabilitation cannot be accomplished in the first place. And more than we say in terms of retribution, we think this is also important, because as long as they are failed to properly punish such kind of victims or the families of victims, are lot of suffering in the first places. That's why I say in terms of social or individual, not only individual level, but also social structure level, because society or minority group itself that believe that this kind of preconception existing within court trial process. In this particular situation, the retribution cannot be accomplished. We think this is particularly harmful because we say the states are become complicit in terms of racial preconception can be available as a means of important that kind of trial procedure. That's why I say this is particularly harmful. So let's talk about how the court procedure will be after plan adoption. First, we say they mentioned, AGU mentioned that the racist is there in such kind of even in that such kind of context. First, we say that even under the subconscious bias can be the criteria in the first place for the individual in the first place, because we say that this kind of both of the such kind of evidence is dubious cases. We think that obvious or arbitrary or subconsciously prioritize this kind of racial bias, racial preconception in the first place. That's why I say even subconscious level, we think this is particularly problematic. Or even under such kind of statistic data in terms of this kind of black people are more likely to commit crime. Even this kind of statistics data also cause such kind of subconscious bias, subconscious preconception of the individual. We think this is particularly harmful. And more than that, we say that even if racist in the such kind of jury group is rare, we think as long as many countries take the consensus rule in terms of deciding decision, we think even small number of racists is particularly influential in terms of decision making in the first place, because they are more likely to forward such kind of they're more or less likely to forward such kind of minority victim in the first place. That's why I said as long as we assume that some kind of racist can be exist even under the subconscious level, we think this is particularly harmful in terms of healthy, no thank you, healthy the discussion, healthy court trial process in the first place. And they also mentioned that such kind of hate crime, yes.
Don't you think it is unfair that police and public prosecutor are able to identify the race and ethnicity of targets, but juries and public can't?
Firstly, we are more than happy to we are happy to make the such kind of police or prosecutor enable to this kind of situation, and that's why there's no exclusivity in the first place. So let's go to in terms of hate crime. So let's talk about hate. First, we say that this kind of law, in terms of hate crime, we think that they are more likely to unfair to the minority in the first place. Let's consider that kind of statistics, because self-defense examination in this particular situation, because for example the white guy that shoots the certain black people, because there's such kind of statistically the black are more likely to commit crime, because statistically proven in this particular situation this can be the mitigator factor under these circumstances. We think but government should not allow, or courts should not allow this kind of particular social engineering in the first place, because we think this is particularly unfair for the black people, as particularly increase the number of discrimination against black people or minority in the first places. That's why I say this is particularly serious problem. And more than that, we say this kind of such kind of mitigatable factor in terms of hate crime cause another kind of crime in the first place. We think this is particularly also harmful. That's why I say in terms of hate crime, we think outside of this failure. So lastly, we already told you that clear mechanism in terms of ignorance failure. We say even assuming that such kind of existence of racism, because we assume the character of racism as such kind of prioritizing, arbitrarily prioritize their own race, even under such kind of particular circumstances. We think thanks to the idea of ignorance fail, we think regardless of racial the identity, we think they in order to tell this kind of their own such kind of racial group, they are more likely to fair judgment, because we think fair judgment maximize their own racial benefit. That's why even assuming such kind of existence of racism, we think we prove that such kind of mechanism of such kind of fair judgment. That's why we are very proud of propose.
I'd like to invite the option whip so you can have him close the debate.
Really, congratulations for the huge burden. O.J. Simpson, Ferguson incident, Birmingham 6, Timothy McVeigh, John Bennett incident of pedophile. These incidents have much to do with racial hatred, Mr. Speaker, because racial hatred was the initial motive for those crimes to commit actual crimes. When you ignore those factors, how do you instigate a proportionate punishment for these individuals in the first place? They have shown us a tokenistic mendaciousness. Let's be nice, let's forget, because race is not important. Races are important for those individuals, because they have much to do with the initial malicious intent to commit crimes. How do you prosecute those people on your side when no one really cares race and ethnicity? And that's the most important point in this debate that my partner brilliantly extended. 3 extensions. First of all, let me engage Kyoto Tiger rather than Achan, because he bullied my friends. by asking too much long point of information. Take point of information from Achan. I would like to take point of information from Masaharu instead. Later I will take it. In what circumstances ethnicity does matter in finalizing verdict and sentencing? Finally, how this proposal shapes the ways in which police and public prosecutor actually act in terms of investigation and prosecution mechanism. So move on to the first issue about Kyoto Tiger. Their main case was about fear of victims. When he supports anonymity, why don't you guarantee anonymity for victims on your side of the house? Just like a rape case, the victims of rape don't have to face offenders under the veil in a court trial. You can guarantee those systems instead of taking this proposal. Secondly, there is no interest of the victims are not the paramount criteria or value in the criminal justice system in the first place. Because criminal justice system has a role to play out the balancing many different kinds of values of retribution or rehabilitation or deterrence and protection society. Thereby the interest of the victim is not the core part of justice system in the first place. Because their perception is extremely subjective. Some victims don't fear. Some victims do have fear. You can't really judge on the basis of that. That's why we believe that value of victims' rights are not really important in the debate. Move on to the second issue. In what circumstances ethnicity does matter in finalizing verdict and sentencing? My honorable friends on opposition bench exquisitely explained the impact over the public perception and the role of courts. But what my partner brilliantly extended its own impact over technical procedure inside the trial. My partner gave courts three core logics. First of all, this undermines the possibility of considering mitigating factors to give proportionate punishment to the criminals. For example, when the suspected criminals live in a community of historical oppressed group and he has been historically oppressed by the majority in those community and commits certain crimes or violent self-defense, do you really consider those acts as a murder or very serious crime? No, we don't believe so. We have to consider racial background in order to give a mitigating factor to these vulnerable individuals. Second of all, when the motive is clearly or intrinsically connected to a racial hatred, how do you give proportionate punishment to those individuals, Mr. Speaker? The mysterious assumption on that side of the house is better rehabilitation, which is achieved on the other side of the house. The purpose of rehabilitation is first to identify what was the motive for that person to commit crimes. When the racial hatred is the initial purpose to commit crimes, then we can have better rehabilitation because we can tackle that particular motive on the rehabilitation program on the jail on the other side of the house. But when these people, for example, Mr. Speaker, society has a hate crime law, which is a murder based on racial hatred, is much more severe than the murder on a random murder, Mr. Speaker. We have to recognize, the courts need to recognize the gravity of malicious intent on the basis of racial background. I will take Masas.
Everything criminal related to ethnic hatred. Why? Please show me why knowing the specific race is necessary for decide. We think only knowing the big criminal hate the race and victims.
No. Otherwise, juries, as you say, from ordinary public, cannot really adjudicate what kind of circumstances, what emotional aspects, what social aspects that these individuals have been engaging in so far. That's why juries should have specific. I don't take one of these from you, sorry. That's why this is particularly important to instigate proportionate punishment. Don't believe my friends anymore. Thirdly, my partner explains criminal justice system plays a role to accommodate the normative standards over jurisprudence by establishing precedents which influence future cases. When the racial crimes, the crimes on the basis of racial hatred happens in the future, it's particularly important to have precedents accommodated by the court system. That's why we need to practice the actual law on the basis of social situation rather than theoretical level, not the role of the courts. The conclusion in the debate is we don't know what kind of broad impacts this proposal brings about society. Therefore, let's compare harm and benefit on the basis of concrete outcome within a court trial. That's my partner extended. Moving on to the final criteria, how police will act is under your side of the house. In the status quo, juries are able to notice racial practice of law and order by police and public prosecutors. But this proposal instigates a moral hazard among or within the police or law enforcement agency. For example, every testimony or witness who are introduced by public prosecutor are testifying against black suspects, then jury can notice that there is something wrong with it. If statistically, overwhelming number of arrested suspects are from same racial community, public and jury can notice the possibility of racial profiling or racially practiced investigation or plea bargaining or indefinite detention. When the police prosecutors know that jury and public would pay no attention to race and ethnicity of each cases, then they further increases the motives to continue those racially practiced investigation, racially practiced interrogation. And that's the problem of your side of the house. In order to ensure the transparency or accountability of investigation mechanisms, jury should have specific right to access information about gender, information about race or ethnicity or sexual preferences in order to further scrutinize the investigation by public prosecutor. All those check and balance mechanisms will be undermined on your side of the house. He suddenly answered to my point of information. He's more than happy to incapacitate the public prosecutor and police to access those racial characteristics of suspects. And if you say so, how is it possible for the public prosecutor to actually arrest the suspected criminals in the first place when the racial crime happens? Right? You have already died in debate. Thank you.